SJC-11981, Commonwealth v. Admelson Resende.
Mr. Levin, we're all ears.
Thank you, Mr. Chief Justice, and may it please the court, Patrick Levin on behalf of Admelson Resende. 2 years ago, this court held that Annie Dukins admitted misconduct in her role as a confirmatory chemist at the Hinton lab constituted the sort of egregious misconduct that could justify withdrawing a defendant's guilty plea if he could show that he had relied in some way upon her representations in pleading guilty. In this case, Annie Dukin performed all of the tasks that she admitted to having engaged in misconduct during, but because she ultimately did not sign the drug certificate as one of the assistant analysts in the case, the judge below held that the defendant was not entitled to the conclusive presumption of misconduct that this court established in Commonwealth versus Scott. Now, the opinion in Scott does speak in seemingly specific language about a defendant proffering a drug certificate with Annie Dukin's signature on the line labeled assistant analyst. However, the point of that specific language in Scott was to distinguish her role as a chemist from her role as a notary public, where there's no indication that she ever had engaged in any misconduct. So the point of this distinction in Scott is that Annie Dukin had to have participated in the case as a chemist and participated in the testing of the drugs in order for the defendant to be entitled to the conclusive presumption of misconduct.
Could I ask you, these are two unrelated questions. The first is, how did this get separated from the case that we heard earlier this year?
It was never part of the same proceeding, Your Honor.
Because
he moved to withdraw these guilty pleas soon after Annie Dukin's misconduct became apparent to the public. He did at that time have the other charge pending, but the two cases were never consolidated. Therein, Special Magistrate Chernoff was hearing the motions to withdraw, and so they just were never part of the same case.
Okay, the second question, thank you. The second question is a factual one. I think the Commonwealth says, so I'm accepting, yes, we're on to what does the chemist do in this case. I think the Commonwealth says that what the setup operator, if that was Judge Chernoff's term, is put already sealed vials in the right order in the carousel. Is that correct? Do you agree with that?
Yes, that's the judge's finding.
Do you agree that that's a correct finding?
In the normal run of cases, that is the role of the confirmatory chemist. They have to calibrate and tune the gas chromatography mass spectrometer instrument. Then they load the vials into the machine and run the machine and monitor it throughout the course of the run. And then at the end of the run, the confirmatory chemist's role is to analyze the data that's produced by the instrument.
Okay, and that's what the Lawler did, correct?
That's right.
So my question, I guess, is, in the role that in this particular case Annie Dukin presumably performed, I'm just as a theoretical matter, where would it have been possible to tamper with the drugs?
Well, we're not asserting that she tampered with the drugs.
No, I know you don't. As a factual matter, I know you're not. I'm just theoretically, how would a person in that role be able to do anything with respect to the drugs?
Well, that's not 100% clear, but the misconduct that was at issue in Commonwealth versus Scott and in two of the companion cases, Davila and Torres, Dukin was the confirmatory chemist in those cases. And what this court said in Scott is her misconduct as a primary chemist, which included the dry labbing, batching of vials, and so forth, and her misconduct as a confirmatory chemist, which was her failure to properly run the tuning tests and to calibrate the instrument before running the actual test.
And would that be the role that she was performing?
Which is exactly what she was assigned to do in this case.
Well, ordinarily, the confirming analyst will be the one doing all of what you were just describing.
Well, that certainly is what we all thought.
Right, and so the confirming analyst in this case, Mr. Lawler, testified extensively about how he checked to ensure that indeed the machine was operating appropriately, calibrated appropriately, samples appropriately, vials appropriately categorized, and et cetera. So that's very different from Dugan doing all the setup and then being the confirmatory analyst, isn't it?
It's
Or she can confirm her own misdeeds as
Well-
opposed to having someone independent double check.
well, so the confirming her own misdeeds is a little bit of a different. That is a problem that did arise in some cases where the same person was both the primary and the confirmatory chemist. But that's not the issue that we have here. The problem with this claim that Mr. Lawler could double check everything that Ms. Dukin did is that part of Ms. Dukin's admitted misconduct involved forging the reports that supposedly certified that the machine had been properly tuned and calibrated in the first place. And Mr. Lawler testified that he relies on the work of the other chemists in the lab, and he relies on the documentation that's produced in the course of their work. And if she's forging these reports, there is no way for him to make sure that she actually did what the documentation certifies that she did. And there was no reason at the time for him to suspect that there was anything wrong with what Ms. Dukin was doing in the lab.
Well, I mean, the judge credited Mr. Lawler's testimony in every respect
Yes.
and concluded otherwise.
Well, what I'm saying is that it's not relevant that
What you're saying is there is a possible maybe something could have happened. Maybe that was so covered up that the confirmatory analyst wouldn't be able to tell that the machine was tampered with.
Yes, essentially yes.
That's the thread that you want us to rely on.
Well, I'm not, so to be clear, I'm not talking about deliberate wrongdoing that would intentionally make the test results wrong.
Well, that's deliberate wrongdoing is what we have presumed here. That's the point.
That's right.
So we haven't presumed it in these circumstances, but in others.
What I'm saying is I'm not talking about intentionally falsifying test results. I'm talking about deliberate misconduct in the sense of deliberately failing to follow the lab's established procedures and make sure that the test results are accurate. And this is the issue. This was Annie Dukin's misconduct as a confirmatory chemist.
Well, okay. So the Inspector General's report, which the magistrate here cites, revealed no evidence that Dukin ever tampered with another chemist's samples. So that's what we're talking about here, right?
That's right, and we're not talking about tampering with the samples. We're talking about failing to follow the lab's procedures to make sure that the test results at issue are accurate.
Well, let's play that out. I mean, let's assume that she, out of laziness or something else, decided I'm going to save the time of actually calibrating and declare them calibrated and then signing the document. Is it your position that if they were indeed not properly calibrated, there would be no way for Lawler to see that?
Yes, that is my position.
Well,
And
or that there's no indication that that was among the things he checked.
that's right. Well, he testifies that he checked to make sure that that the quality control standard was correctly identified. But the calibration report that he would have been double checking is the report that Dukin admitted to having forged on at least one occasion. So the fact that he double checks the documentation that has been produced by the machine doesn't show anything other than the documentation looks the way it's supposed to look.
Okay, but if it had been incorrectly calibrated, what is the likelihood that the outcome would have been that it's said to be cocaine? Which is
Well,
what-
I don't know the answer to that, Your Honor. But what I do know is that these kinds of test results aren't admissible in court without having laid a foundation that the machine was working properly and had been calibrated first.
I thought the judge found that Lawler had the responsibility of reviewing the operation of the machine as well as whether it was set up properly.
Well, when we're talking about whether it was set up properly, what the judge found was that he reviewed the placement of the vials and made sure that they were in the correct order. But it doesn't, what I'm saying is it doesn't matter if he reviewed the calibration report because we don't know whether she forged the calibration report. And that's the only thing he had to look at to make sure that the machine was properly calibrated.
If I can turn you to prong 2.
Sure.
Okay, let's assume that you prevail on prong 1. He would be going to trial. Let's assume he knows all that we know now. Okay, why would that affect his likelihood of pleading guilty? He would know that he would have both the field testing and, more importantly, the preliminary, the testing done before the confirmatory testing would be available, all of which would say it's cocaine, which is what he said it was when he was selling it to the undercover officer. Why would that materially affect his decision to plead guilty here?
Well, it's not clear, first of all, whether the field test results and the primary chemist's benchtop tests are sufficiently reliable to be admitted in evidence over a Daubert-Lanigan challenge without the confirmatory test to back them up. And arguably,
So, I mean, the field testing, I understand that to be an issue, but the primary testing?
as far as I know, the primary testing is more or less the same test as the field test. I mean, these tests they're preliminary benchtop tests, and the reason that we do the confirmatory tests is because they're not 100% accurate.
Okay, but he would have to then calculate, I've got to then do a Daubert-Lanigan challenge, prevail on that, and then argue that to the jury, if I go to trial, that the Commonwealth cannot meet its burden of proving that what I said was cocaine was in fact cocaine.
Well, and the fact that Annie Dukin has been involved in the testing in his case is a ground of argument to the jury that you can't trust beyond a reasonable doubt the results of the testing. Secondly, those test results potentially are excludable as unreliable in toto as to the counts that Ms. Dukin touched, which are all the lead charges in this case. And I think the most important thing on prong 2 is simply the fact that there wasn't a plea bargain here. He didn't get anything from the Commonwealth in exchange
But he
for
had
pleading
Judge
guilty.
Ball.
That-
She wasn't going to try the case.
Well, Your Honor, all I'm saying is there was no consideration offered here. And certainly the possibility that a better bargain might have been negotiated is one of the factors to look at in deciding the second prong issue. And the idea that a better bargain than no bargain at all would not have been on the table is not really credible in a case where the shadow of Annie Dukin's misconduct would have hung over the entire trial.
I take your point as to that, but if I'm correct about Judge Ball's modus operandi, I gather she would have a sidebar conference. Is that on the record?
There's nothing on the record as to
There's
that.
nothing on the record as to what was said with regard to the plea negotiations.
No. All we
the
know
plea
is that he
discussion.
came in and offered an unagreed tender, asked for the mandatory minimum, and the prosecutor asked the judge instead to sentence him to 4 to 6 years in state prison.
So we don't know whether this case was lobbied at sidebar or in her lobby.
From what appears in the record, what happened is he came in and asked for the mandatory minimum. The prosecutor asked for 4 to 6 years in state prison, notwithstanding the fact that he was a teenage defendant with no criminal record.
Okay, thank you.
Thank you.
Good morning. May it please the court, Laurie Yeshulis for the Commonwealth. With me today is Lisa Jacobs. She was the motion prosecutor in this case. Your Honor, if you'd like to begin with the second prong, I could pick up where my brother left off, or we could
So
start with the
going
first
back, since we had the motion prosecutor, she would know, was there a lobby conference before the plea?
Not the plea prosecutor. She's the motion prosecutor on the
Motion
evidentiary
prosecutor,
hearing.
so we don't know who was
Don't-
there for the actual plea.
Don't know, but what we do know with regard to the plea is that the defendant was sentenced to the minimum mandatory on the like charges. For example, on charges 1, 3, 5, 7, 8, and 9, he was charged with a minimum mandatory of 1 year in the House of Correction. For those counts each, he faced 2.5 years in the House of Correction or from 2 to 10 years in a state prison sentence. He was sentenced to all of those charges concurrently. So there really was nothing to go down from, to plea from, if you will.
Did he know at the time he tendered the plea what the sentence would be? I'm not talking about whether there was a lobby conference, but had his lawyer told him that this is what the judge will do in the case?
The defendant did not testify at the motion hearing, and he received an adequate plea colloquy, and he's not complaining that he did not. And that would have been one of the questions that was asked during his plea, whether he had reviewed the charges and with his counsel. So I didn't look specifically that through the plea hearing, but we would have to just presume that that's the normal course, and there's been no complaint about that.
Did the judge say during the plea colloquy, I know sometimes the judge will say what the sentence is going to be. Did Judge Ball indicate during the colloquy what the sentence would be?
I don't recall that. That wasn't an issue raised on appeal. I do know he pled to the minimum mandatory. He requested the minimum mandatory. It was an unagreed plea. Judge Ball sentenced him to those 6 charges, minimum mandatory concurrent, when each of them could have been consecutive.
With respect to the counts, I think it's 8, 9, and 10 that
Yes.
Annie Dukin was not involved with, correct?
Yes,
None of those had the school zone attached to them?
they did not, but again, counts 8 and 9 were distribution charges for which he faced either what he received, the 1-year minimum mandatory in the House of Correction, could have been sentenced consecutively. On the marijuana count, count 10, he could have been, that carried a 6-month sentence. But he could have faced, with those charges, 2.5 to 10 years in a prison sentence. So he was sentenced to the minimum mandatory on those charges, and the marijuana count was placed on file.
Well, the defendant says that he couldn't have done any worse by going to trial. I think that's what he says.
I'm not sure that he can, that one could make that statement. If he were found guilty at trial, he would have faced the minimum mandatory from 1 year in the House of Correction up to 10 years in prison for each of those counts, just on counts 8 and 9. So, and the marijuana count would have been a 6-month sentence.
Well, the sentencing judge at that point would have had would not have had to accept the minimum mandatory. Could have given more, is your point.
Absolutely.
So you can't say he couldn't have done worse.
Absolutely. In fact, he pled to the absolute minimum he could have pled to on these charges, the absolute minimum. There was no other plea agreement that would have been available to him.
Unless you drop some of the charges. Right, but I know,
Right.
that's,
So in regard, just going backwards just a little bit on this, while we're on the second prong, I want to talk about the field tests. And I cite to Commonwealth v. Marde in my brief, and in that case, it talks about field tests and their admissibility at trial. And what it says, and it's supported by Commonwealth v. Connolly, what that case says is if you have a field test that is corroborated by other evidence, it is likely that it will come in. And here we have a lot of corroborative evidence. We have the field test, but we also have 5 undercover buys. We have the defendant's implicit admission that what he is selling is rock as opposed to powder cocaine. We have how those controlled, or excuse me, undercover buys were conducted, as far as calling the same phone number, meeting at the same meet locations, selling the same type of material each time to an undercover officer. So under Commonwealth v. Marty, when you have a field test, that is corroborated by other circumstantial evidence, and it's subject to the Dalbert-Lanigan test, it will be admissible. Now, there hasn't been a case yet where that's come before this court, but under Marty, it is clear that those would be the circumstances, so long as the foundation was properly laid, and there's no suggestion here that the Commonwealth couldn't lay that proper foundation, then those field tests would have been admissible. And so regardless of the drug certificates, the fact that these substances were cocaine would have been before this jury, or a jury.
With respect, now turning to the first issue.
Yes.
Mr. Levin says, you know, the one thing that she could do to invalidate the test, or that, and that Scott suggests that she, I mean, that she did do was not always calibrate and do what you're supposed to do. So,
Right.
what do you say to that?
I say we look to the IG's report, which was in evidence in this case. And now, keep in mind that Scott was published the day after the Inspector General's report
Yeah,
was
but
released.
so we would have to. Here's my question: would we, to accept your proposition, would we have to basically revise Scott?
Absolutely not. So Scott stands on its own record. This case stands on its record, and as part of this case's record is the IG report. And what we find in the IG report is some of those admitted misconducts. In the conclusion or the findings by the Inspector General, the Inspector General talks about in May 2011, Annie Dukin was in charge of quality control. And during that time, she actually had 4 days where she admitted to, I just want to get the language straight, she admitted to signing QC standard mix reports on the GCMS instrument, which were incorrect. That was 4 days. And when the IG talks about their findings and what they concluded, I think they're referring to those 4 days of forged GCMS reports. In addition, in their findings, they talk about that she forged a GCMS control sheet, a GCMS batch sheet. So this didn't happen throughout her entire tenure there. And in fact, when they found these breaches, the IG went back and looked at 3,930 samples and did not find any other malfeasance with regard to GCMS control sheets.
How do we know that that was a reliable reassessment of what she had done?
Well, the IG did an extensive review. I agree with you. So then what we have to do is take what Lawler testified to and take a look at, could this have happened as a setup operator? Could she have tampered with the vials? And keep in mind, when these samples are going into the machine,
Well, that's not the only question. It's also about this certifying that it works, isn't it?
Correct. So and please bear with me. So when we look at, and I'm looking at the defense's record on page 109, and then going forward. So what happens in these cases, and I think the defense mentions it in their brief, and it's mentioned in Lawler's testimony in the IG report, up to 120 vials will go into this machine. They're all sealed. There's samples of unknown substances, there's standards, there's QC mixes, and so they all go in and they're all sealed. And so what the confirmatory chemist does at the end of the run, he takes a looks at everything. And if you look through what he actually looks at, not only is he looking to make sure that the samples in this case test positive for cocaine, he's looking at the standards to make sure that those fragmentation patterns also match. But not only in this case. If you look at the powder sheet for this run, which again is on page defense's record 109, everything tested in this batch was cocaine. So when Lawler looks at that documentation at the end of the run, he's looking at all the standards. The standards all have cocaine in them. He's looking at all the samples. Everything that tested positive had cocaine, and the fragmentation pattern would have matched. So to answer your question, if she tampered with these vials, or any of these vials, none of the standards would have matched cocaine. So in other words, she would have had to tamper with every single unknown sample, every single standard, every single QC mix, and that Lawler would have noticed some sort of problem with that, and there's no indication of that. As a matter of fact, in this case alone, I took the liberty of going through the defendant's record and taking a look at the substances and the fragmentation patterns which were not subject to Annie Dukin as setup operator. And if you look, and I'm not a chemist, but if you look at the fragmentation patterns, the numbers all match.
Now, did the Inspector General retest or review the 4 days' worth of items that Annie Dukin had been responsible for and forged documents to?
I'm not certain through the IG's report that he did, or that they did, but I do know they recognized that there were problems with those 4 days and went backwards from 2002 to 2012 to see if there was any other misconduct and found none.
So the testing in this case was 2006.
Absolutely. So again, if you look through, so not only would Annie Dukin have to tamper with the samples in our case, she'd have to tamper with the substances and I counted about 55 other samples that were in this batch.
So how would the Inspector General know that they hadn't been tampered with?
There is a larger sample. He may have been able to, I'm not sure of how he performed his investigation, but my guess is he would look probably at some of these tune reports.
Yeah, the vials just contain a small fragment of the actual sample.
Correct. He'd have to, the larger bulk sample would be in the evidence room or with the primary chemist. And that's another point in this case. I mean, Daniela Frasca received positive cocaine test results in this prior to anything going to Annie Dukin. So Annie Dukin, in a sense, she's as what Lawler testified to and what the motion judge credited is she put them in the right sequence, recorded the correct sequence, put them in the machine, turned the machine on. They're sealed when they go in, and when they come out, Lawler, the confirmatory chemist, and he's called the confirmatory chemist, and he signs that sheet because he is the one that's going to go into court with his signature on that certificate and vouch for everything that went before him. Not for the primary chemist test results, but for everything that he confirmed. He confirmed the vials were in the right order. He confirmed the standards tested positive for cocaine. The QC mix tested positive for cocaine. These unknown samples tested positive for cocaine. He signs it, he's vouching for it, he's responsible for it. And as the judge found, he also was responsible for checking everything the setup operator did up until that point. So if he was the person doing the setup, he's vouching for himself. But as a confirmatory, signing that, he's vouching for Annie Dukin as well.
Right, but your brother says he can't confirm as to the calibration. Is that correct?
What Lawler testified to and what the judge credited is that documentation that gets printed out at the end of the run would have been able to see whether or not there was any problems. In fact, I think the judge made a finding that he actually was able to determine whether there was any problems with the machine throughout the run. And he found that there were no problems with that run. And
I take it if the calibration had not been set right, then all of the many, many samples that the machine tested would have been essentially inconsistent with the primary testing.
correct.
And therefore would have required a whole different set of procedures to...
And Lawler would have been able to see that. What he testified to was cocaine has a unique fragmentation pattern. And so if it wasn't calibrated or tuned properly, he would have seen that right away. That was his testimony. It has a unique pattern. If it wasn't there, he wouldn't have been able to confirm it.
Can I ask you a question, not related to this, but I read about how many vials go in here. Are they all related to this case? I mean,
No.
do you really put in 100 vials?
You can put in 100,
You
I
can,
believe.
but I mean, how do you, I thought they just tested one case at a time.
No. In fact, if you look at, I think it was 109 again, and you can see, actually, if you look at page, I'll make it easier for you, on Defense Record 121, it lists everything that went into the sample, and you can see
Is this in the
Defendant's Record
appendix?
Appendix, yes.
Yeah,
On
okay.
page 121 is just a good example of how you can see that. So on the top, you have line, vial, data file, method, sample name. On the right-hand side of the sample name, if you go down, here are all the samples. Our samples are about a third of the way down, 779099. About just past halfway down is 779110. Towards the bottom is 779125. In between all that are blanks in other cases. So Annie Dukin would have had to tamper with every single case and blank and standard and QC mix in order for this theory to be correct. And she would have had to do it undetected. And Lawler said you cannot do it undetected. There is no way, it's an impossibility.
So it's in Lawler's testimony, if we review it, where we will find this concept that the cocaine has a unique fragmentation pattern, and an improperly calibrated machine will produce results that would have shown an obvious error in the calibration had the machine not been calibrated.
His testimony, and unfortunately, we don't have verbatim testimony because of the problem with the stenographer, but what we do have is, yes, the agreement was there was a unique fragmentation pattern. That was the agreement of everyone present at his testimony. And he said he would have checked the vials, he wouldn't have gone forward, and he tested the known sample to the fragmentation pattern of the known sample to the unknown sample, and they matched. And if they didn't match, he would have been able to tell that. And I'm paraphrasing from his testimony.
Are you saying that unique is unique to each sample, not unique
Unique
to
to cocaine.
Well, that's sort of
He
what...
says
So if you were tampering and you wanted it all to come out cocaine, which is presumably the point here, let's just say, you'd stick a small amount of sample of some cocaine, something you knew was cocaine.
into a
and
sealed
you'd get all
vial.
that.
But that would require penetrating the sealed vials.
Yeah, I understand that part, but I just
Right.
wanted to
Calibration.
So the
clarify.
calibration
Can't
of
tell this
cocaine
is-
comes out to one, fragmentation pattern equals this.
Right.
So every single sample tested in that machine of cocaine from this day, from every day afterward, has a unique fragmentation pattern. To a chemist would be obvious.
Unique in that it's cocaine.
Unique in its cocaine. But in order to tamper with these samples, you'd have to tamper with all the QC mixes, all the standards, and every single sample that was tested in this batch.
All right,
Thank
thank
you.
you.
Thank you, Your Honor.